Good afternoon. Thank you for joining us today for Foley & Lardner's web conference, Fashion Law 2018 Year in Review. Before I turn the presentation over to our speakers, I'd like to go over a few housekeeping items. Today's program will last approximately 1 hour, followed by a short question and answer session. We encourage you to submit written questions during the program. Please type your question into the Q&A widget open on the left-hand side of your screen. We will respond to questions at the end of the program, time permitting, or we'll follow up with questions following the program. The webcast console you are looking at can be completely customized. You can resize or move any of the windows that you have open, including maximizing the PowerPoint presentation on your screen. If you experience technical difficulties during the presentation, please visit the webcast help guide by clicking on the help button below the presentation window, which is designated with a question mark icon. The PowerPoint presentation will be available on our website at foley.com in the next few days, or you can access a copy of the slides in the resource list widget on the left-hand side of your screen. As a reminder, today's program is being recorded and will also be available on Foley's website in the next few days. Foley will apply for CLE credit after the web conference. If you did not supply your CLE information upon registration, please send an email to Taylor Bannister at tbannister@foley.com to be eligible for CLE. You will need to log into the On24 session and answer a polling question during the program. Please note, certificates of attendance will be distributed to eligible participants approximately 8 weeks after the web conference via email. As a final note, those seeking Kansas, New York, and/or New Jersey CLE credit are required to complete the attorney affirmation form in addition to the polling question that will appear during the program. A 5-digit code will be announced during the presentation. Please email the form to Taylor Bannister at tbannister@foley.com immediately following the program. At this time, I would like to turn the presentation over to today's speakers, Laura Ganoza and Julie McGinnis. Laura is a partner and litigation lawyer based in Foley's Miami office. Julie McGinnis is an associate and trademark attorney based in Foley's Milwaukee office. Thank you.
Thanks a lot, Taylor. This is Laura Ganoza, and I would first like to welcome everybody to this web conference. We really want to thank everybody for being here, at least virtually with us. I know that some of you may actually want to be here physically with me in Miami, given the weather this past week. Maybe not so much with Julie in Milwaukee, but nonetheless, we're happy that you're here joining us on this web conference. We are really excited about this presentation. There have been a lot of very interesting developments in the world of fashion and apparel, and we thought it would be important to review what's happened this past year and, just as important, its implications for the industry going forward. So, Julie, why don't you kick it off by just kind of going over what we're going to be talking about here today.
Sure. Thanks, Laura, and thanks, everybody, for joining us. We have kind of a packed agenda today with a lot of a good variety of cases and topics to talk about, all of which have had or will have an impact on the fashion industry this year. So the agenda is in front of you now. We're going to walk through some decisions, some pending cases, and some other kind of one-off issues that fashion companies should be thinking about. And then we also have a little preview for you with some cases and things that we expect to be important this year. So with that, I will jump right into our first case. Some of you may have participated in a webinar we conducted about a year ago involving the Star Athletica versus Varsity Brands case, which was a Supreme Court decision involving the copyrightability of cheerleading uniforms. As a refresher, that decision came out in March 2017, and it announced a two-part test for determining when a pictorial, graphical, or sculptural element of a useful article, like a piece of clothing, is eligible for copyright protection. That test held that an artistic feature of a useful article is eligible if the feature can be perceived as a 2- or 3-dimensional work of art that is separate from the useful article and if that feature would qualify as a protectable pictorial, graphic, or sculptural work either on its own or in some other medium if it was imagined separately from the useful article. As a refresher, here are some of the cheerleading uniforms that were at issue in this case, and the elements of the cheerleading uniforms that were determined to be eligible for copyright protection were things like the stripes, chevrons, zigzags, and the various placement and color of those items on the cheerleading uniforms. So following the Supreme Court decision, the case went back to the district court. The parties ended up settling the matter in August of 2017. And so we don't have the benefit of that district court's assessment and application of the Supreme Court's new test. However, there have been some other courts that have interpreted the Star Athletica ruling in connection with determining whether elements of apparel are copyrightable. And we thought it would be helpful to go through those because we're starting to see maybe a little bit more guidance as to how courts are going to be applying that test. The first case that we have for you is Silvertop Associates versus Kangaroo Manufacturing. This was a case from this year out of the District of New Jersey. Silvertop had alleged that Kangaroo had copied the design of its copyrighted banana costume. So on the left, you have the copyright owner, Silvertop, which is also known as Rasta Impasta, and on the right, you have the alleged infringing costume from Kangaroo. So in this case, the district court granted a motion for preliminary injunction. Applying the Star Athletica test, they determined that when you view this banana costume as a whole, there was a reasonable probability of success that Silvertop could show that it owned a valid copyright in the design of the banana costume. And the court went through and looked at several features of the costume that it determined had a pictorial, graphic, or sculptural quality. And those are things that list right here, things like the overall length of the costume, the shape of the banana, the length both above and below the torso of the person wearing the costume, the shape, size, and color of the ends of the banana, the location of the cutouts, the particular qualities and characteristics of the fabric that was chosen, the parallel lines that run along the length of the banana, and then the particular shade of yellow and the fact that it was a uniform color that made it look different than a normal piece of fruit. So the next case, these next two cases are actually from 2017, but we thought it would be really helpful to go through them because there are only a few cases that are really applying Star Athletica. The next case is Triangl Group. In this case, the Southern District of New York granted a motion for a default judgment and a permanent injunction involving alleged infringement of Triangl's swimsuit design. So Triangl has a swimsuit design that features different placements of color blocks and trim. And the court, in assessing whether to issue the permanent injunction, looked at the test in Star Athletica and determined that most of Triangl Group's swimsuit designs were copyrightable because the black trim and the specific T-shape on the top of the bathing suit were considered physically separable and demonstrable as works of art. So looking at the bathing suit, if you kind of compare it back to the cheerleading uniforms at issue in Star Athletica, we're talking about the placement of stripes and color blocks and shapes. And applying that to this case, the court said those items are copyrightable. The third case we have for you involves a couple of different designs. This is LA T-shirt and print versus Rue 21, also a 2017 decision out of the Southern District of New York. In this case, there were several animal designs that were used on T-shirts that LA T-shirt and print had obtained copyright registrations for, and the court found that these animal designs were eligible for copyright protection, and that specifically that several elements were found under the test in Star Athletica to be protectable. The first of the designs is what they are calling the ornate elephant, and that appears on the right-hand side of your slide. And a couple of the elements that they found were, the particular pattern, the particular arrangement of the concentric circles on the elephant's legs, which are a little difficult to see, but the particular design on the elephant's head, and basically the placement of these geometric figures and designs, and also the original use of colors, since the red, blue, ivory, and black, and the particular color on the tusk and the toes are not the colors that you would typically see on an elephant. And then lastly, the specific pose and posture of the elephant. The next couple of designs are what they refer to as tribal bear and party bear. And in this case, there were, again, several different elements. LA T-shirt owned a separate copyright registration for this particular Navajo pattern that appears on both of the bears. The court said, this is a distinctive arrangement of geometric shapes, including the triangles and diamonds, and that was protectable. It also found that the placement of the accessories on the bears, so the sunglasses that they're wearing, the headdress on the tribal bear, and then the red cup, the fact that each of them is holding a red party cup. And also, again here, the specific arrangement of the colors and the colors that were chosen, and then the specific poses of the bears. And it's also important to note with this case that the copying and substantial similarity was not challenged. So it was really about whether these designs were copyrightable. And so the court, looking at these, applying the test in Star Athletica, found yes, they were, yes, these designs were copyrightable. And so, we can expect to see more decisions along these lines. The Star Athletica test has given brands another tool in their tool belt for challenging infringements. And another tool that is available and that is becoming more widely used is trade dress. So Laura, why don't you tell us about the recent decision in the ITC involving Converse?
Sure. So the Converse case involving their very popular Chuck Taylor brand and line of products, this case has been kind of bouncing back and forth for some time, but we got a very interesting ruling just recently out of the Federal Circuit. The Federal Circuit reversed a prior decision from the International Trade Commission, which had invalidated the Chuck Taylor Converse sneaker design and found it to not have the secondary meaning. So how did we get here? Let's get a little bit of history of how we got here, and then we could talk about why this decision is important and what it means going forward. So back in 2014, and there's the image of the shoe that we're all talking about. In 2014, Converse filed an ITC proceeding, and that's what's interesting about an ITC proceeding is, unlike in federal court where you can seek money damages in addition to an injunction, things like that, the remedy that you're seeking in the ITC, which is the International Trade Commission, is to stop and prevent the importation of the allegedly infringing goods. So it kind of puts a stop to anything coming into this country. And back in 2014, Converse filed a proceeding in the ITC against more than 30 different respondents, claiming that they were infringing their trade dress in this Chuck Taylor design. And they actually do have a registration for this design, and it's listed here. And what they're claiming makes up the distinctive design or the trade dress, it makes up three elements. It's the two stripes on the midsole of the shoe. They also claim that it's the front design of the toe cap and the design of the multi-layered bumper in the front that has a bunch of different design patterns in the front, and how all these things relate to each other. So that's what Converse claimed is their trade dress. They obtained a trademark registration on that on September of 2013. And in this proceeding, originally the ITC actually rejected the Converse claim because they said that the trade dress was invalid on designative grounds. Basically, they said, no, it hasn't acquired secondary meaning, and therefore you can't, it's not a valid trademark, you can't protect it. And the reason this is important is because unlike word marks or even product packaging, a product design trade dress like this, what Converse is claiming in this case, cannot be inherently distinctive under case law. So in order for a brand owner to protect a design, they have to actually prove that it acquired secondary meaning. So the ITC found, nope, there is no secondary meaning here. So that was appealed, and the Federal Circuit went back and rejected that. And I'll go through some of the arguments that were made and what the implications are here. So what ultimately the Federal Circuit held was that, yes, you have this registration, and usually you have a presumption of validity with your registration. But unlike Converse contended, it doesn't apply to all infringers. It's only going to apply as of the moment of the registration. So it becomes very important to know when these accused infringers when they launched their products. So the alleged infringers that were still remaining in the case, they claimed, hey, look, I've been using my design for a really long time before September 10th of 2013. So that was before you have any kind of statutory presumption that you have secondary meaning on this design. So, and the Federal Circuit decided, well, the presumption is only going to apply only as of the date of the registration, and it's not going to apply to anything that happened before that. So for a brand owner to be successful, they're going to have to go back and say, well, my design was distinctive and had secondary meaning before the accused products came into the market. So that's a change, and that's going to be one element of the proof. And, that's going to make it a little bit difficult sometimes, because one of the ways that you try to prove that there has secondary meaning is with surveys. But if surveys are done, present day, or the proof that you're putting in is the current proof of what your design is, that's going to be difficult to be able to show what it was back then, especially if it was a long time period prior to when these surveys or this evidence is being gathered. So that's something important that is going to have to be addressed by brand owners that are trying to prove secondary meaning, especially when the alleged infringers have been using the accused product for a significant period of time before they acquired a registration, or especially if they haven't acquired a registration. Another thing that this case did is it said, well, there's a lot of different tests out there to determine what is secondary meaning. There's a lot of different factors. So now the Federal Circuit actually clarified and set forth its own new test, and they determined that there's 6 factors that are now going to be, that should be used to determine whether a mark, like a product design in this case, has acquired secondary meaning. And they're all listed here. The first one, again, is the association of this trade dress with the source. When somebody sees a Chuck Taylor design, when somebody sees that design with that, white sole in the front and those markings in the front bumper, is that associated with Converse and Converse alone? So typically, again, that kind of stuff is done through consumer surveys. That's going to be one of the factors. How long have they been using it? And the degree of exclusivity. Also, they're going to look to see, are there third parties out there that are using marks that are similar? And advertising. What kind of advertising, how much have you done? Are you doing look for advertising, where you actually tell a consumer to look for these features that you're claiming that are part of your trade dress? Sales, whether people are actually copying you and what kind of media attention you're getting. So this is a new test, and in fact, just recently in December of 2018, the TTAB issued a precedential decision that said that this is the new test that they're going to be adopting because the Federal Circuit clarified it, and they're going to be adopting it as well. So you're going to be looking at this not only in court proceedings, but also administratively before the Trademark Office. Another thing that this case did was it also talked a little bit about once this goes back, how are you going to determine a likelihood of confusion? And the case talked about, well, what is the standard for a likelihood of confusion when they went back, when you have to go back and compare the Chuck Taylor trade dress to these accused infringers. And the test is a substantially similar test. The court basically said it's similar to the product design that we do in patent law that requires an ordinary observer to perceive that the two designs are substantially the same. So that's going to be what the ITC is going to have to go back and look at in reassessing whether, in fact, these products infringe the Converse design. So Julie's going to talk about another case where a brand owner is trying to use a product design element in enforcing its rights. In this case, it's Levi's, which is a very fierce protector of its pocket tab. And so, Julie, why don't you talk a little more about what's going on in the recent case about that?
Sure. So Levi's, like you said, Laura, Levi's is a very fierce protector of its intellectual property and specifically of its pocket tab. The case we're going to talk about today is a case that was filed this year, so it's still pending. Levi's filed an infringement suit against Yves Saint Laurent in the Northern District of California. The suit claims that YSL infringed on Levi's registered trademarks for its pocket tabs. Levi's does own several registrations for various iterations of the tab. Again, this case is still pending, so there's been no decisions on the merits. But we thought it would be, it highlights a couple of good points on issues like this. You can see here on this slide the Levi's jeans with their pocket tabs on the left, and then the alleged infringements from YSL on the right. So, as I mentioned, Levi's does own several registrations for its various iterations of the pocket tab, and this case that was filed against YSL is a long line of cases that have been brought by Levi's over the years. Levi's brought a suit earlier in the year against a company called Kenzo, and you can see here on this slide the pocket tab that Kenzo was allegedly using on some of its denim products. And so really the takeaway here with the Levi's case filed against YSL is, looking at clearance activities, and when you're looking at clearance activities, looking at the litigation history of what is found in those clearance activities, because that may give you some guidance as to how likely or how strongly a brand is enforcing its IP. Another case, which is not on the slide but was just announced, there was a decision announced yesterday involving another Levi's case. That was a declaratory judgment action brought by J. Barbour & Sons. This was, I believe, also in the Northern District of California. The court dismissed a declaratory judgment action because of the timing that it was filed, and so there's a lot of activity going on with Levi's, and so that just sort of highlights the importance of looking at how a brand is enforcing its IP, because that may give you some guidance as to what you can expect if you are, trying to adopt something that, might be confusingly similar. So that's really the main takeaway with this case. Another interesting case this year that was also recently filed kind of highlights a recent trend in the increase in brand partnerships and partnerships with maybe brands you wouldn't necessarily expect would work together, and how that shift in how brands are doing business might impact how we look at likelihood of confusion and how we look at trademark infringement cases. And that is a case that was recently filed against Balenciaga this past year. So Laura, why don't you tell us about what happened in that case?
Sure. So recently, Balenciaga was sued by Freshener Corporation, and a lot of you may know Freshener. They're the ones that have the air fresheners that are usually in the design of this little tree, and you put it in your car and various other places. Well, they sued Balenciaga late last year in the Southern District of New York, claiming that Balenciaga's Keychain, which is there on the left, infringes their tree design for their car fresheners. And this case was just recently filed. It's still kind of in the earlier stages. The plaintiff filed claims for trademark infringement. They also filed for registered trademarks, but also unregistered. And under unfair competition, they also filed a claim for dilution. Balenciaga recently filed an answer in the case, and it's interesting, one of their claims is that, well, this is a generic shape or it's functional, or in any case, it doesn't operate as a trademark. And one of the things they did was they cited to an old utility patent that has now been expired that the plaintiff once held, and apparently in that patent, it had some kind of description about the utilitarian purposes of the tree shape, or otherwise why it was functional. So obviously, if they're making some kind of statement that this is functional for some reason, then that's going to take away from the claim that it's operating as a proper trademark. So that's still going on, and it's going to be interesting to see what happened. As of yesterday, I checked, and it looks like a mediation is scheduled in this case for next week on February 8th. So we'll see what happens. But in the meantime, like Julie mentioned, one of the reasons we thought it would be important to raise this case is just that we have seen a lot of these collaborations, more recently, where you wouldn't necessarily put two brands together. It starts a lot with, you have certain brands that are in Target where you never would have found them maybe before. Or you have a collaboration like a Fitbit with Tory Burch. She's a women's wear designer, but here she is with this electronic, fitness device. So the market, having seen these collaborations, we're wondering, what is this really going to mean for making these arguments in court as to whether there's going to be confusion or not? Because maybe before you could have made a very definite argument that, a luxury brand is a luxury brand and it's not going to be confused with something as, a commodity as an air freshener. But nowadays, maybe a consumer is going to maybe think that those kinds of different elements could come from the same source because of so much collaboration that's out there. So it's definitely something to think about as you're thinking of putting together these claims and you're analyzing the different factors that are going to be involved in either a trademark or dilution analysis. Thinking about the type of consumer, what they're expecting to see, may be a little bit different now considering where the market is going. So two other very different types of brands that are battling it out or have battled it out in courts is Gucci and Forever 21. And Julie's going to talk a little bit about a recent development in that case.
Sure. Thanks, Laura. This case, Forever 21 filed a declaratory judgment action against Gucci. It was filed in 2017. The declaratory judgment action was filed in response to demand letters that were sent from Gucci to Forever 21 involving Gucci's stripe trademarks, which are a series of blue, red, and blue stripes, and then a green, red, and green stripe. In the declaratory judgment action, Forever 21 claimed that these stripes lacked the necessary secondary meaning to function as trademarks, and it also sought cancellation of the trademark registrations and refusal of a couple of pending applications that Gucci had pending with the trademark office. So not surprisingly, Gucci counterclaimed for trademark infringement, dilution, and unfair competition. To give you a quick look at some of the designs that are at issue, here's a couple of examples of the alleged trademarks blue, red, blue, and green, red, green. On the left image is the Gucci product, and the right image is the Forever 21 product. So kind of an interim development in this case was that in February of this past year, Gucci had requested dismissal of the trademark cancellation claims, and the court rejected that request. And so Gucci tried to get rid of the possibility of their trademark registrations being canceled, and were unsuccessful in that interim proceeding. There was a filing made in November which indicated that the parties settled their dispute. The settlement terms were, not surprisingly, not disclosed, so we don't know, what other issues or what may have been the end result. But the filing of this case does give us a couple of takeaways and a couple of things to think about. The one is that the sending of the main one is that a reminder that the sending of a demand letter to in an attempt to enforce your IP can immediately trigger a declaratory judgment action from the other party, and so that's just a reminder to be thoughtful in the claims that you're making in your demand letters, and be thoughtful in sending them, and ensuring that you sort of have your ducks in a row and you have the wherewithal and evidence to prove your case at trial, because the sending of the demand letter may not it may result in a lawsuit being filed against you, and you need to be prepared for that. That's really the key takeaway from this case, obviously, because it's settled, because we don't have any other decisions on the merits. But it is a really important one, especially for brands that do a lot of enforcement and are constantly sending out demand letters, and remembering that any of those parties could file a lawsuit in response to the demand letter that you send. Another issue that brands need to think about and be guarding against is making sure that their trademarks continue to function as trademarks. And so I'll turn it over to Laura so that you can talk about Genericness, a case involving UGG sheepskin boots, and to talk about how we can use this case to protect against a brand becoming generic.
Great. Thanks, Julie. So the case that we want to talk about is Deckers Outdoor versus Australian Leather Company. And Deckers is the owner of the UGG trademark, and they sued Australian Leather in connection with its use of Uggs, the term UGG, in connection with boots that they were selling. In response, Australian Leather said, wait a second, UGG is just a generic term. It's just a generic term for a type of sheepskin boot. You can't own it. Nobody can own it. And so it's not infringement of what we're doing. And in defending the claim, the defendant argued that they went all the way back into history of where this all came from in Australia, and said that this is how people referred to these particular types of boots in Australia. They went to shop owners in Australia, and in the U.S., they were really focused on kind of a smaller group of people. They said that American surfers use these a lot, and they referred to them generically as UGG. And so that was the evidence that they had. It was really based on kind of the shop owners and then this history in Australia and this group of surfers. On the other side, though, Deckers provided a survey, and their survey showed that 98% of the respondents viewed UGG as a brand. So this was a really effective way to use a consumer survey. It was obviously one of the things that convinced the court that, in fact, UGG was a brand and functioned as a trademark and was not generic. They also, both parties, submitted a lot of evidence, but there was evidence on the plaintiff's side from a linguistics professor, historians, and a lot of that supported that, at least here in the United States, UGG is not used generically in footwear, and to the greater public, the consuming public of who's going to buy these UGG boots, which the court actually said it's usually women from, I guess, I forget the exact demographic, but, it was like 16 to 54 or something like that. They're not going to refer to it as UGG as a generic term. Maybe some American surfers are going to do that, but not the general consuming public. So that's a really kind of important takeaway of, you have to know who the consumer is when you are defending or even bringing these kinds of actions when you're claiming genericness. You have to know who the target market is, because those are the consumers that it's going to matter as to what they think of the trademark. So that's important to remember. And then just, again, in general, just tips for avoiding your mark becoming generic. Always use it as a trademark, as an adjective, and modifying the noun. It should be UGG sheepskin boots, but I have to confess, in preparing for this presentation on more than one occasion, I said, oh yeah, the UGG's case. And Julie had to correct me and say, no, Laura, it's the UGG sheepskin boots case. So that becomes hard, but as a trademark owner, you have to do that and make sure that you use it as a trademark, give the proper trademark notices, R in a circle if it's registered, TM if it's not, use in distinctive text if you can, make it larger, different color, different font. Don't use it in the plural like I just did. Try to avoid that and do something else that Deckers did. I think Deckers realized that this was an issue because on their website, they actually educated the public about their brand and told the public, this is our brand and this is what it means and this is where it came from. But they had a whole section on their website about UGG as a brand as opposed to a type of thing. So educating the public is important. And speaking of educating the public, another really important topic when it comes to public, especially in the fashion and apparel world, is the use of influencers. It has had, a huge effect, especially in the fashion industry, but it could also get you in trouble. So Julie's going to talk about some developments in influencer and FTC guidelines, just to make sure, as a refresher for those of you who already do this, or for some of you who are not. She'll give you some guidelines about best practices in this area.
Sure, thanks, Laura. So again, like Laura said, influencer partnerships are everywhere. Fashion companies, but every type of product, every type of consumer product is using influencers, and if you're not, you probably will be soon. A few years ago, the FTC released a guide, some guides concerning the use of endorsements and testimonials and advertising, of which a lot of these influencer sponsored post type things come about. Subsequent to that, they've also published some additional guidance, kind of a Q&A format with some additional guidance that relates to specific types of social media. If you are not familiar with those guides, I would highly recommend giving them a read, as well as the follow-up materials that the FTC has provided. They provide a lot of really good instruction on what your obligations as a brand owner are, and some helpful tips to comply with the FTC's requirements. These guides that they have prepared are a basis for voluntary compliance with the law. So if you can show we followed the guides, that likely puts you in a good position. Example here, obviously everyone knows the Jenner and Kardashian family are huge in the influencer world. Lots of brands are working with them, want to work with them. They have huge following. So we have for you here just one post that obviously reflects a partnership or influencer relationship between Kylie Jenner and Puma. It's really important to remember that practices that are inconsistent with the FTC's guidelines can result in corrective action from the FTC. I'm not going to review some of the corrective action measures that have been taken by the FTC. They are publicly available online. One takeaway of those is that they're often pretty onerous requirements, and they often last for a long time, 5, 10, 20 years. So you do not want to find yourself in the crosshairs of an FTC corrective action, because impose significant cost and obligation on your marketing teams and on the brand as a whole to make sure that you're complying with them. Under the current law, as an advertiser, as a reminder, you can be subject to liability for a false or unsubstantiated statement that is made through an endorsement. And where it's really important here with influencers is failing to disclose a material connection between the advertiser and the endorser or influencer. The endorser themselves can also be liable for statements that they make in the course of their endorsement. So what can you do? And what should you be doing as a brand? As a brand, you have an obligation to train and monitor the people that are in your network. So if you are hiring social media influencers, Instagram influencers, if you're giving people product, making sure that they're educated about what their responsibilities are to have truthful disclosures. Couple of elements of training programs, explaining what they can and can't say. If there are claims about your product, this is maybe less in the fashion space, but if there are health claims or performance claims about athletic apparel or something like that, educating them about what they can and can't say. Making sure that you have very clear guidelines about how they're supposed to disclose the connection, if they received a free product, if they're a sponsor, if they're a partner. Another obligation that you have as a brand is to search and to follow up if you are discovering that your influencers are not following these requirements. So if you discover, you can't bury your head in the sand. So, doing periodic searches of, hashtags for your brand on social media and making sure that the people that are in your influencer network are doing what they're supposed to be in their disclosures. You may want to develop a training program. It's really important to get influencers to understand that if there is any incentive whatsoever, they need to disclose that there was a relationship. The most common one is a monetary payment or a free product, to generate a review or a post. But even if those products aren't expensive, even if it's just a headband or a hair tie, that's still compensation that they're receiving and they need to disclose. But compensation can also come in sweepstakes entries, chances to appear in your advertising. It can come in the form of agreeing to make a charitable donation, or even just paying for expenses like travel and accommodations. Maybe to attend a photo shoot or to, come to your brand. When in doubt that they're receiving something, they should disclose that there is a relationship. What's really important and what the FTC is looking at is how good is your disclosure, and where is that disclosure appearing? Because if the disclosure of the relationship, if your influencer's disclosure is not adequate to show consumers that there is a connection, then you can be liable. So here we have a couple of just sort of practical tips, and these are actually taken from some of the FTC's further guidance on social media posts. So if you are, if influencers are making YouTube videos reviewing your products, the disclosure should be in the video itself, meaning the person making the video should say, I got this product from such and such brand in exchange for this review, or, so-and-so sent me this product to review, something like that. Or I've partnered with X brand, to bring you this. It shouldn't be buried in the description, which somebody has to click through to see. In Instagram, it should be either in the photo or in the first 3 lines of the text. Why? Because on Instagram, the first 3 lines show up, and a person who's just scrolling through their Instagram feed has to click to see the rest of the post. If someone has to click through to see the disclosure, it is likely not adequate. Any of the platforms that have story features, so Snapchat, Instagram, and Facebook stories, the disclosure needs to be easy to notice and read in the time that someone has to look at an image. So if the image is only on the screen on Snapchat for 8 seconds, then the disclosure can't be the last fraction of a second before the story closes. It should be long enough that someone can read it and understand it. And then Twitter, obviously more limited with space. The FTC has said that starting a tweet, the keyword is starting the tweet, not ending the tweet. Starting the tweet with the hashtag ad would likely be an effective disclosure. A couple other things you can do, making sure that your brand has a social media policy that can be applied uniformly across the brand. I mentioned this earlier, but making sure that you're monitoring for compliance. A really important thing to remember is that the FTC has said that you cannot delegate this responsibility away. You can obviously have contractual arrangements and maybe some indemnification, but you cannot just delegate away your responsibility to your PR firm or to a third party. It will not relieve the brand of responsibility if there are issues with the disclosures and the statements that your influencers are making. And, following up on those non-compliance issues, again, you can't bury your head in the sand if you know and you learn that people are not doing what they're supposed to. You can use contractual agreements to some extent, but again, important, you can't shift the liability not to an outside firm, but you also can't simply shift the liability to the influencer. Both you as a brand and the influencer can be held liable by the FTC. So that is really important to remember. Again, if you are not familiar with the guides or you haven't reviewed them lately, I would suggest taking a look at them and the FTC's additional guidance that's available on their website. The FTC is, starting to take more enforcement action. We can, expect to see more enforcement. Another area, kind of changing subjects, but another area where there has been an uptick in enforcement and activity is your brand's website. And there are a number of lawsuits that have been filed in recent years involving compliance of your websites with the Americans with Disabilities Act. So, Laura, do you want to tell us about what's been happening there?
Sure. So this is kind of a new little cottage industry that a lot of plaintiffs' attorneys have created. And I know as the litigator in me, when a client first gets sued with these claims, I really can't believe it because they haven't seen it before. But what these claims involve is that the plaintiffs are visually impaired individuals that are claiming that a particular website is denying them access because they don't have complete equal access to the website because in many cases they fail to include certain reader software or other technological elements that would make it easier for them to have full access to the website. And so you wonder, well, what does this have to do, how does a website have to comply with the ADA? And it stems from this notion that websites have been determined to be places of accommodation. So this notion that you have to accommodate for disabilities is not just limited to physical locations like the actual physical restaurant or the physical store, retail store where you're selling clothes. Instead, it also includes the website where you are promoting the clothes that, you're selling maybe in your retail location or not. So the ADA is going to apply. It's going to apply to your website. And, if you haven't been sued yet for ADA, you're very lucky because these cases are out there. They're out there every day. I monitor new filings in South Florida, and I can tell you that there are new filings every single day, at least a handful every single day, just in the courts down here in South Florida. In New York alone, just in the first quarter of 2018, there were nearly 300 ADA cases filed in just New York, and everyone is being targeted. It's not just limited to fashion companies. Restaurants and a lot of other industries are being targeted, but a lot of fashion brands have been targeted. We just listed just a few, just to give you an example of who is being sued on these kinds of cases. So what should you know about it? You really should conduct an ADA compliance audit. You should really see if your website does comply. and does have the features that allow full access to people with disabilities. There's a good guide. We have the link here, the WC3 Web Content Accessibility Guide. It provides some guidelines and tells you certain things that you need to look at in terms of trying to comply as best you can with to make it more accessible. And really the notion is to make your website easier to see and hear, or for people to see and hear the content that you have in your website. There's also some software out there that you can plug in your website, and it can assist you in knowing what you are or not compliant with. But things to just keep in mind generally is to maybe provide alternative types of text for, and maybe not everything in actual text itself, but have more pictures, have them in larger print, or have it so it could be accessible with a Braille reading software, things of that nature. Again, it's providing more alternatives in your website so that it's not just limited. And another thing that's interesting in these cases is, in addition to claiming there's ADA compliance issues, now there's a new claim that to the extent that you have to click the cookie policy, which everyone now probably has new cookie policies because of the recent changes in privacy laws, there's new cases that say, well, I can't click that because I don't have access, I can't see it, so now you trespass onto my computer because you have cookies and I didn't know about it. And the reason these cases are filed is because the plaintiffs are entitled to attorney's fees. Whereas you can't really get damages under the ADA itself, you can get attorney's fees awarded, and that's why you see these kinds of cases. And they result in, a lot of the settlements are going to result in you having to put together a guideline that you're going to have to monitor over a period of time, in addition to some kind of monetary settlement. So it's really important to just know that these things are out there, to do your best to be compliant, and just to learn more about it and speak to your IT folks to make sure they know about it as well. Oh, and now I guess, Taylor, do you want to give some information for those of you trying to seek some CLE credit?
Yes, thank you, Laura. At this time, I am going to read the CLE code for this program. If you are in need of CLE credit today, please enter this 5-digit code into the poll question on the screen after it is announced and press the Submit button. The code is YTG33. Y as in yellow, T as in tree, G as in green, 3 as in the number 3, 3 as in the number 3 again. Again, the code is YTG33. Again, if you are seeking CLE credit for this session, please complete the polling question by entering the code that was just announced. The polling question will remain open briefly. For those seeking Kansas, New York, and New Jersey CLE credit, in addition to the polling question, you will need to complete the attorney affirmation form, enter the code that was just announced, and return the form immediately following the program. A copy of the form can be found in the resource list widget. As a reminder, certificates of attendance will be distributed to eligible participants approximately 8 weeks after the web conference via email. Finally, one last time, the code is YTG33. At this time, the poll will now close. I would like to return the program over to our speakers. Thank you.
Great, thanks, Taylor. So we have one more case from 2018 to talk about today, and this is a case involving sales tax collection and the Supreme Court's decision in Wayfair v. South Dakota. This case has had and will have a significant impact on fashion retailers of varying sizes. So we thought it would be good to review the court's decision and kind of give you a preview of what you should be looking for and what to expect. So this is a case involving South Dakota's tax law, which required a collection of sales tax from any vendor with more than 200 customers or revenues exceeding $100,000. Wayfair challenged the constitutionality of this state sales tax collection law, and it made its way to the Supreme Court. The Supreme Court issued a decision last year which overturned an existing law that had constitutionally prevented states from compelling a retailer to collect sales tax from a mail order or internet business if the retailer did not have a physical presence in the state. So now, as a result of the South Dakota v. Wayfair decision, states can collect sales tax from out-of-state online retailers on consumer purchases. So what does this mean? Like I said, this case will have a significant impact on retailers. As of the end of 2018, there were 31 states with similar tax laws that required taxation, that required that retailers collect and remit sales tax on internet purchasers. Most of these state laws follow the South Dakota model, so there is a threshold, meaning typically more than 200 customers, or if you have revenues greater than $100,000. And so, this may not impact a small one-off shop like an Etsy shop or something to that effect, but it may affect brands that otherwise would not have been captured. This $100,000 threshold is relatively low. It's also important to note that states have already started enforcement actions in enforcing these sales tax collection laws. So brands should assess whether you have a proper and compliant tax collection procedure in place and continue to monitor changes in state law, because as a result of this decision, it would not be surprising if the remaining states that do not currently have similar laws on the books, start to make some of those changes. So that is the end of our 2018 presentation, but there's a couple of things on the horizon, and we thought it would be a good idea to give you a little bit of a preview of things we should be looking out for this year in 2019. So with that, Laura, I'll turn it over to you to give our sneak peek.
Great. Thank you. So the first thing we should all kind of know that's coming is that the Supreme Court has decided to hear arguments on a case involving whether a ban on registering scandalous trademarks is unconstitutional. Some of you may remember in 2017, the Supreme Court tackled the issue of disparagement and whether a ban on disparaging trademarks is unconstitutional. In that case, there was a rock band that wanted to register the mark Slants, and it was refused. It ultimately went up to the Supreme Court, and it was struck. The notion that that mark could not be registered as disparagement was struck down. So now, though, the issue is a scandalous mark, and it comes up in the context of a line of apparel brought by Brunetti. They wanted to apply to register the mark FUCT, F-U-C-T, for a line of apparel, and it was refused based on the notion that, no, you can't register this scandalous trademarks. So the Federal Circuit struck down that ban. The USPTO has appealed, and now the Supreme Court says, okay, we're going to hear it. So it's going to be interesting to see what they do with now scandalous trademarks. But interestingly, it came up in the note, it came up through a line of apparel. So, the fashion industry is, having its effect in the Supreme Court. Another one case that's going to be up in the Supreme Court that's going to have really big implications, I think, in the fashion industry is this Mission Products Holdings versus Tempnology. And this involves, what happens when what happens to a trademark license when the brand owner goes bankrupt. And I think this is going to be a very significant issue in fashion because there is so much licensing going on in this industry. And right now, the law is really in flux. There's a lot of circuit split on what happens. So the Supreme Court is going to hear arguments next month as to whether a licensor can just reject an existing trademark license once it goes into bankruptcy. And like I mentioned, the circuits are split in deciding this issue, and it stems from the fact that generally the law in bankruptcy is that generally a debtor has the ability to reject certain of its contracts automatically upon declaring bankruptcy, but there are exceptions for certain intellectual property. Specifically, the statute mentions copyrights and patents, but the statute doesn't specifically mention trademarks. And because of that, there has been this circuit split on the issue as to whether a licensor can automatically just stop and say, nope, look, no more upon declaring bankruptcy. And there's a big issue about it because, licensees tend to invest a lot of time and money into the brand that they've licensed. And is it fair to them that because the brand owner is declaring bankruptcy, that all of a sudden all of that hard work, money, resources will be pulled? So the court's going to tackle this issue because it came up. In this case, it was the Federal Circuit allowed the licensor Tempnology that owned the mark Coolcore that was used with sports apparel to stop the license from proceeding. So we're going to see how that goes. And that brings us to the end. We're right at 1 o'clock. If anyone had questions, we'll go ahead and after the call, we'll make sure to respond. So we're sorry we can't do that. But if anyone also has any specific issues, this was a very general overview. It was surely not exhaustive, and there's a lot of other issues going on in fashion law. If anybody has anything specifically, please don't hesitate to contact us. Here's our contact information. But we do hope that you found this valuable. And you will all be getting a survey afterwards, and we'd love to hear if there's any other topics in the future that you'd like us to cover talking in this industry and in this topic area. And thank you so much for attending. We hope you enjoyed it.